Contracts 1 General Principles Revised. Today's topic for discussion is the most important chapter from Contracts 1 General Principles, that is Quasi Contracts Revised. This lecture was uploaded long back. This is an improvement over that lecture. This is my 200 lecture. In this connection, I wish to remind you that I have delivered 199 lectures so far. Up to 146 lectures exclusively in English media on 18 subjects. For the convenience of student friends, at the request of my student friends, I started delivering in both English and my mother tongue, Telugu language of Andhra Pradesh in India, at the request of my student friends. Since then, I am consistently delivering both English and Telugu simultaneously. The students of English media can have an opportunity to have my lecture on each and every topic. So my ambition is to complete 30 subjects, but in which subject I have completed more than 10. The subject is almost completed tentatively. For advanced studies, you may refer the books of your choice. Now, after this lecture on Quasi Contracts Revised, there will be a small lecture left over, that is wagering contract and contingent contract. It requires half an hour. I will finish it, and then I will go to last chapter, remedies, and after remedies, last chapter, I will take one lecture on important questions and answers on Contracts 1, and what are the questions to be prepared first and other questions to be prepared later. I will explain with reference to Contracts 1, and other guidelines I will give for the purpose of all the subjects, right from first semester, first subject to last semester, dear friend. In this lecture, I wish to take up quasi contracts. In this lecture, we have to discuss what is quasi contract, what is the meaning and the definition of quasi contract with reference to underlying principles, what are the various kinds of what are the different kinds of quasi contracts and our quasi contractual obligations we have to discuss today, dear friends. Before going to commence my lecture, let me take just a minute to pray God, pay homage to my reverend parents, late Raga Prao and late Srimati Kantaratnam, my beloved wife Mrs. Balivada Raga Tirumala Gauri. I express my deep sense of gratitude to my godfathers who are instrumental for what I am now. Let me express my heartfelt gratitude to the publishers of textbooks and authors of articles and research papers in internet, whose works I am making use of for uploading these lectures. Finally, I express my deep sense of gratitude to my student friends who are instrumental for what I am now, in particular for having improved my channel to the 10,000 subscribers. Let me expect similar cooperation from your side, so that I can have very good inspiration to serve you better. So, dear friends, keep in mind, out there are nearly 30 subjects prescribed for study for 3-year LLB course, but practically point of, for example, competitive examinations, judicial officers exams, group 1, group 2, civil all, around 15 to 18 subjects are very important from all these exams, and contracts, law of contracts, negotiable instruments act, specific relief act, these two, sale of goods act, these three will come within contract subject only, and easements act will come within the meaning of transfer of property act. Like this, IPC, CPC, CRPC, evidence, administrative law, constitutional law, all these vital subjects I have delivered in detail, alternative dispute resolutions, and 18 out of 18 subjects that I covered so far are relevant to all the competitive examinations. However, I will take up the remaining subjects But there are some subjects like trust and equity, insolvency and bankruptcy, insurance. Some subjects are there. There are some institutions they are optional. Some institutions they are made compulsory. So such subjects can be taken up later. Let me take up the first subject. I wanted to take up labor laws, but in view of labor codes, I had to postpone that process. Intellectual property also I got prepared, but it is not that much urgency. International court observation, drafting, pleadings, moot court. These subjects don't require much explanation. Anyway, all these things I will take up in course of time. Let me complete in thoroughly the burning subjects who are very important, essential for all the vital exams like All India Bar Examination, Judicial Officer Examination and competitive examinations. Don't think that all this is some hammering. It is for your good information only. Now I wish to take up quasi contract. Quasi contract means contract basically emerges from an agreement. Agreement is created by entering by two parties. Any contract is emerges from agreement. This agreement is created by two parties coming together, making valid offer and valid acceptance. When valid offer and valid acceptance is extended, constituted, to do an act or not do an act or abstain from doing an act for some lawful consideration, then an agreement is created. This agreement will become enforceable through court of law in the event of breach from either of the side, provided certain other conditions are satisfied. The capacity of parties, free consent, legality object, etc. Okay. This means in by when a contract agreement is created, when an agreement is entered into, or ultimately if it is has valid conditions of contract and contract is entered into, some rights and obligations are created between both the parties. The rights of one party will become the duties or obligations of other party. The duties or obligations of the rights of other party will become the duties of this party. For instance, seller goods, an agreement is entered into for sale of goods. Seller has an obligation to deliver the goods, and buyer has an obligation to pay the money. Seller has a right to ask money. Buyer has a right to deliver money. So seller's right becomes duty of purchaser. Purchaser's right becomes duty of the seller. Both purchaser, seller, or vendor or vendee, as the case may be. So in a contract, that contract is tangible contract. That contract, if a contract is entered into for transaction, it is called it is tangible. But there are other transaction contracts or agreements that contain some bond imposing rights and obligations on the parties in two ways. In the absence of an agreement or any contract, rights and duties are created. When rights and duties are created in the absence of an agreement, without entering into an agreement, though that contract or agreement is called intangible contract or intangible agreement. This type of situation takes place in two ways. One is rights and duties created by law. Rights in law of torts. In law of torts, rights and duties are created by law. The rights, Winfield tells that tort is the tortious liability arises from breach of a duty primarily fixed by law. This duty is towards person generally and is redressable by action for unliquidated damages, like that. In law, when you drive the vehicle, you are supposed to, you have obligation not to cause any damage to bystanders or pedestrians on the road and following vehicles and opposite vehicles. Where you have freedom of speech, you are not supposed to extend your misuse your freedom of speech guaranteed under Article 19(1)(a), speaking some nonsense, making some defamatory statement to another. So this duty, you never enter into any agreement to extend such duty or obligation. Such duty or obligation is imposed by law. So you have, if you breach it, other person will have right to bring an action against you. So tangible. A tangible contract or agreement contract is created by entering into two parties for a particular transaction. Intangible bond, imposing rights and creating rights and obligation take place in two ways. One is the rights and duties created by blah. Other is rights and duties created by principle of equity, principle of natural justice, principles of justice, equity, good conscience, principles of morality, principle of the concept of moral science. That is what is called. There are certain circumstances in which without entering into any agreement, rights and duties are created. Either one party breaches his duty, the other party, it results in injury or damage to other party. The person who has received loss or damage, that is aggrieved party, can bring an action. Then in such a case, the wrongdoer cannot say that there is no any agreement to that effect, there is no any contract to that effect, I cannot be held liable, is what this wrongdoer cannot say. So this is under with reference to the principle of natural justice, principle of justice, equity and good conscience. This concept of quasi-contractual liability is created out of the principle, equity principles, that unjust enrichment cannot be accepted, cannot be entertained. This is the position. For I give you some practical example. Suppose when you go to bank, the cashier has given you extra money. It is your duty to give it return back. Sir, you have given me extra money. So suppose sometimes you have already paid for some article, some 100 rupees or 200, but you forgot it. Have I paid you? Shall I have to pay? The shop owner should say that, sir, you have already paid. You should not say that, no, you have not paid, and you should not take it for 2 times. That is like this. When we find some goods belonging to other, it is our duty. We should not make use of them for ourselves. We have to find out the real owner and tell. Suppose when an amount is wrongly credited to our bank account, we should not make use of it. When we know, when we get credit to our account, when we get debit to our account, when once we get some unexpected credit from unreliable sources, then we have to bring this matter to the notice of banker and see that that credit is reverted. So like this, these are such obligations are called quasi-contractual obligation. Suppose you are a shop owner or you are some hotel owner. A customer, after finishing his breakfast or lunch, left his handbag containing cash, left his umbrella or left his any belongings. It is a owner, you have quasi-contractual obligation or duty. Keep that goods at your counter. When the party comes back, naturally he will come back asking you, I forgot my bag, like this. Then it is your contractual duty or obligation to return that. These are the issues relating to quasi-contract tentatively in common parlance. Now let us now discuss what is quasi-contract meaning. The word quasi-contract is derived from the Latin word quasi, which means as if, similarly or similar to. Quasi, that is one thing. So it is derived from Roman law, obligatio quasi ex contractu. This means it is not an agreement. It's like a contract. A quasi contract is an agreement, not an agreement in reality. It looks like an agreement, but the quasi contract is not a contract in reality. It was not created out of agreement entered into between two or more parties. It is created by principles of morality, principles of equity, justice, equity and good conscience. The good conscience. And that's so. That is this is the principle is no one shall enrich any benefit at the expense of other. So there is a maxim: nemo debit locuplateri ex alina jactura. That means no one should grow rich out of another person's loss. One cannot grow up to rich at the loss of another person. So you should not eat anything breaking the belly of another person. This is another. So in simple, no one shall enrich any benefit at the expense of other is the ideal behind this quasi-contractual obligation. Even though an agreement, if an agreement is entered into between two parties, both parties are binding to each other with reference to rights and obligation. But in certain circumstances, even without entering into an agreement, the parties' rights and obligation are created under the principles of rights and created by law. It is a tortious obligation. If rights and duties are created out of principles of natural justice, that is. So, in a tangible, in agreement is tangible that creates rights and obligation, and non-tangible agreement is quasi-contractual obligation as per equity principle or tortious obligation as per as imposed by law. So this is the meaning with reference to quasi-contract. There are several definitions for that. Salmon has defined, Mansfield has defined, Dr. Jenks has defined. The contents of the definitions are almost identical to these words. You can refer one or two definitions and present in the exam. We say this quasi every exam appears. In every exam, this question appears either as a main question or a short question. That is the reason why immediately after meaning and definition of contract, I uploaded this lecture long time, but this time I have been delivering and uploading these lectures as per serial order. So far I have completed more than 9 lectures. This is 10th lecture, 10 in English media, 10 in Telugu media. Then contingent contract I will take up, remedies I will take up, then I will question and answer. Whatever I have completed in revision, there will be absolutely sufficient for examination point of view to the students of average and above average student. If the students of high standard can go through this thing. So like this, coming to the point, kinds of quasi-contract. So chapter 5 containing section 68 to 72 of the Indian Contract Act provides for 5 kinds of quasi-contracts. Quasi-contracts are, quasi-contract normally I will tell you, where are you working? I was working in State Bank. So is it government? No, quasi-government. Where are you working? I am working in aided law college. Is it government? No, it is quasi-government. Where are you working? I am working as a university professor. Is it government? No, it is quasi-government. So, even though this is state government servants and central government servants are purely civil servants, they are entitled to get protection under Article 311 Clause 2. This topic I will take up in services in constitutional law too shortly. And thus constitutional protection is not available to the those who are working in quasi-government services, LIC, government undertaking, banks, government undertaking organizations, in respect of which salary and other benefits including pension is being paid by central and state government. Though they are pure central state government, they are the civil servants. Treasury, Tahsildar office, collector office, defense, army, navy, air force, they are pure civil servant. And those who are working in nationalized bank, those who are working in universities, who are working in there are some central schools, and if there is a state government, pure government college like in Maharashtra or Tamil Nadu, that is the pure government. So this is why. So quasi-government means there is not a government, but whatever privileges and benefits are available to government employees, same privileges and benefits are available to these employees also. That is why you can say that if a university professor is asked to say, are you a government employee? No, I am not government employee, I am quasi-government employee, he can sell. So this is with reference to quasi-contract meaning in definition, Salmon definition or Dr. Jenks definition, Mansfield definition, 1 or 2 definitions you can by heart and write it. And regarding kinds, chapter 5 containing section 68 to 72 of the Indian Contract Act provides for, speaks about 5 kinds of quasi-contracts. First one is necessity supplied to minor, section 68. Payment made by interested person, section 69. Non-gratuitous act, section 70. Finder of lost goods, section 71. Payment by mistake or coercion, section 72. These 5 sections provide for 5 kinds of quasi contracts. 5 kinds of quasi contracts. Now coming to the point, 5 kinds of quasi contracts. First one is supplies necessities supplied to necessaries or necessities supplied to minor. Generally, a minor is not liable for under the contract. When a contract is entered into with minor knowingly or unknowingly, even by misrepresentation, minor is entitled to enjoy all the benefit, but he is nowhere responsible for, he has no obligation to meet any liability, meet any loss. Suppose if you take minor as a partner, if firm gets profit, he will get the share of the profit. But if the firm gets losses, he is not answerable to the losses. He cannot be declared as insolvent. That is why a minor, if when we enter into contract for some good, from any specific purpose, personal purpose, but the minor is not is not responsible. He is no way answerable to any losses. So that is why a contract entered into with minor is void ab initio. I told in detail about a minor in capacity of contract in previous chapter. A minor below the age of 18 years is minor under section 3 of Indian Majority Act 1875. Similarly, according to Majority Wards Act, I think, if the age is extended to the age of minority is extended to 21 years if any guardian is appointed. So, if a person, boy or girl, below the age of 18 years is minor, if guardian is appointed, whether natural guardian or legal guardian or testamentary guardian or guardian appointed by law to look after his personal property and property, if guardian is appointed, the age of minority extends to 21 years. If minor guardian is there, 21 years is age of minority and 18 years is minority. After completing 18 years or 21 years respectively, a particular person, boy or girl, will become major. So below this age of 18 years or 21 years, if any contract is entered into, that minor is not answerable to any liability. This was laid down in by Privy Council in Muhri Bibi vs Dharmadas Ghosh, wherein the minor entered into contract of mortgage. He received advance of 8,000. Later, neither he accepted 12,000 and handed over the property, nor returned the 8,000. The minor's mother brought an action that the contract, the agreement with minor is not maintainable, but the court decided in favor of the minor only. On appeal to Privy Council, Privy Council also said contract with minor is void. These details in these particulars facts I explained in detail in capacity of parties. So generally, when a contract is entered into with minor, minor is not responsible. Minor breaches the contract, the other party brings an action, that suit will be dismissed as laid down by the Privy Council in Muhri Bibi vs Dharmadas Ghosh. But for when a person supplies necessaries or lends money for any basic needs of the minor, necessities, food, clothing, shelter. Good. Suppose the minor took food in a hotel or mess for 1 year and he did not pay, that hotel owner can bring an action. Food is necessity. Suppose a minor took a flat for rent and he did not pay the rent, he can, this is food, shelter is necessity. Food, clothing, for clothing and other things, basic needs, he took loan from somebody. If minor avoids payment, that person who supplied clothes and other things can bring an action. Food, clothing, shelter, medical expenses, marriage expenses, funeral expenses, all these things come within the meaning of necessity. In addition to that, Some more items may be added depending upon the circumstances of the case, depending upon the status, social status and personal status or financial status of the minor. So, but the concept of necessities was not properly defined. It will be decided depending upon the circumstances of the case. Basically, a minor is not liable to meet any liability, but if the liability is with reference to basic needs or necessities or necessary, the minor is less responsible. In this particular case, Kunwarlal versus Sorasmal, 1963. In this case, minor did not pay house rent. In an action, when the landlord brought an action, it was held that the minor has to repay the rent because it comes within the meaning of necessary. In another case is Kedarnath versus Yajundia. In this case also, some marriage expenses was made. The minor had to pay some marriage expenses and did not pay. When the creditor brought an action, the court said that this is the minor expenses come within the meaning of basic needs, necessaries, the minor must pay. Similarly, it is for funeral expenses of near or dear, the minor is bound to pay. This is with reference to minor. Necessities applied to minor. Section 68 is an exception to the minor's liability. According to section 68, in respect of necessaries applied to minor, a minor is liable to pay. This topic is over. Second one is payment made by interested person. What do you mean by payment made by interested person? Payment made by interested person is like. The next one is, suppose there are certain circumstances, a person may be constrained or forced to make certain payment, though he doesn't have obligation to pay, but for which he would be put some problem, but for which he would be put for some inconvenience or problem. For example, there is a tenant is there, so he is paying rent periodically, regularly. That house owner is receiving the rent regularly and periodically, but house owner, that is landlord, defaulted municipal tax or Nagar Parishad tax, municipal tax. Then so many reminders were given, but the landlord did not pay the house tax, and the municipal authority servants came, decided to evict the house, seize the house. But if the house is seized and the tenant is required to vacate the house with family, in such case, this tenant may not be able to quit the house, vacate the house and go. He cannot get shelter immediately in minutes or hours. So that is why to get relief from the burden, from the approaching danger, he paid house tax on behalf of the house owner. He made all sincere efforts to contact the house owner, but the house owner was not contacted. He wanted to inform, house owner was not contacted. From his personal money, he paid tax to the municipal authorities and got relief from the eviction. Subsequently, he informed the house owner, "Sir, I have paid, municipal authorities came to evict the house for a default of house tax, but I made all sincere efforts to contact you, but I could not contact you, and hence I was constrained to pay the house tax. You please pay that house tax of 10,000 rupees paid by me, or adjust it against future rent, house rent." Then that house owner or landlord said, "Who asked you to pay tax? You paid without my consent or without my knowledge. I know so many people and so many officials are known to me in a Nagar Parishad office, that is the municipal council office, and I could vanish or they would reduce the house tax. You paid CMO on your own without my knowledge. I am nowhere responsible. I don't pay." If the landlord tells like that, he can bring an action. There is no any agreement to that effect. With reference to rights and duty, but out of the principles of natural justice, principle of equity, The house owner or landlord has an obligation under the principle of equity, under the principle of enrichment. He has to repay the money with interest if necessary. If the tenant approaches the court, the court will direct the landlord to pay the money. This is what is called payment by interested person under section 69 of the Indian Contract Act. Third one is non-gratuitous act. Non-gratuitous act means an act done for nothing. So this is practically, we see, we are in this modern world, we are getting material from through couriers, Amazon, Flipkart, and so many things are there. Suppose the Amazon boy or Flipkart boy or courier boy delivers any article to one person instead of another person. Subsequently, there may be identical names, there may be fictitious names, there may be in some Pune in a nearby there is a Palace Plus 2. One is Palace Plus Society, that is on the way to Datta Mandir. There is any Palace Society is there. So there are if fictitious names are there, fictitious name with reference to flats, buildings, and customers also. That is why the incidence of giving wrong delivery takes place. When once wrong delivery takes place, the real consignee will complain to the consignor Amazon. I paid money, but I have not received the consignment. Then after making necessary inquiry, it would be detected that it was delivered to wrong person. When once it was delivered, it was detected, ascertained that it was delivered to wrong person. The courier boy visits the person to whom the wrong delivery was given. Then that person should return that money, return that article. If it is a consumable article, if it is suppose of fruits or mangoes or cake or something like, so that he has to pay that money. He should not say that no, we thought that it is a free gift from Amazon. We are also the customer. That is why we consumed it. We need not pay. Is what that person who received wrong delivery should not say. He should then if he does so, the consignor, Amazon or Flipkart or courier can bring an action against that person to recover the payment with interest and costs of the suit also. This is non-gratuitous act. Third point is over. Section 70. Fourth one is finder of lost goods. Section 71. Finder of lost goods means when suppose class is over, some student left his cell phone, and one student should not make use of it, and he has to keep it and give it to the right owner next day. Suppose when we find any article, whether any cell phone or a bag containing cash or any article, it is your duty to keep it and give it to the real owner. As a responsible citizen, as a responsible person, you have to make necessary inquiries and find out the real owner and return that article, goods or article or bag containing cash or umbrella, anything. It is your duty, but you should not make use of it. I found it, I can enjoy. Is it what? You should not say like that. You should not say like that. This is finder. So a finder of lost goods is, we are in a normal life, we lose so many things. We leave our bag, in some place, we leave our umbrellas, we leave our cell phones in some places. This type of incidents of forgetting takes place, we lose it. When the person found that particular article, he is called finder of lost goods. The finder of lost goods has a duty like bailey in a contract of bailment. What is bailment? Section 148 to 181 of Indian Contract Act lays down various provisions relating to bailment. Bailment, pledge and pledgee, bailment and pledge. This topic I explained in detail in contracts to lecture. But bailey means, bailment means delivery of goods by one person to another. The bailer, the transferor is called bailer and the transferee is called bailey. The contract is called bailment. The bailey must take care of the goods after the purpose is finished, purpose is accomplished. Bailey should return the goods to the bailer. For example, where two-wheeler or four-wheeler is given to some garage for servicing or repair, the garage owner must take it, treat it, keep it very carefully, must do servicing carefully, make repairs very carefully, and give it back safely to the real owner, customer. If he makes misuses that two-wheeler or four-wheeler and exchange the remote, changing the parts, spare parts, etc., that is a breach of duty on the part of the bailee. The bailee, a finder of lost goods, is like a bailee who is shouldered with the responsibility of take care of goods and return the property to the real owner. It is a movable property, is the real owner. Otherwise, he is liable. He is liable. So he has in bailment is written agreement. It is a tangible agreement. But in quasi contractual obligation under sections 1 to 71, it is intangible quasi contract, intangible obligation. There he is a tangible bailee. Here he is intangible bailee. What are the rights and duties? What are the duties and obligations a bailee is having? The finder of lost goods also is having. Suppose the lost goods is mangoes or fruits, he can keep it in storage. Suppose if it is a bag, he must keep it in locker. And whatever expenses the finder of lost goods has paid, he can recover that money from the real owner. So the finder of lost good is like a bailee. He has a duty to make all sincere efforts to find out the real owner and hand it over. If for preservation of the article, if he spends anything from his pocket, he can recover that money from the real owner. So with this section 71 is over. Well, fourth one. Last one is payment by mistake. Payment by mistake or coercion. Payment by mistake or coercion. This takes place quite obviously. Payment by mistake or obviously. Suppose when we go to market in shop, first we pay money. And seller gives article, and we forget that have I paid, and the seller should say, yes sir, you have already paid, he should say, but he should not take it for second time. Similarly, when we go to some seminars, national seminars, and this thing, they may give some suitcase or kit they will give. In some prestigious seminars, they will give suitcases or any bags or something. For one participant or resource person, they will give one, and having received one, if they ask, if they gives, we should say, I have taken. We should not take it for a second time. Suppose when you go to bank and draw the cash, in counter double payment is given. Instead of 1 lakh, 2 lakhs is given. It is your we have quasi contractual obligation to return the money. So this is what is called payment made by mistake. For example, A, B are two friends. They borrowed, A and B are friends. They borrowed 50,000 rupees from a money lender, C. They are very close friends. They enjoy more or less or equally, whatsoever may be. But after some time, A repaid the money 50,000 with interest to the money lender C. And after some time, C also, without knowing this fact, went to the money lender C and paid that 50,000. When B makes an attempt to pay 50,000 with interest, it is the C has a quasi contractual obligation to say that no sir, not necessary, your friend has already paid. That is that, and he should say, if he receives it, and when they both B and B discuss, have you paid, and then the discussion comes, they both will approach the C. It is C has the duty to return that 50,000 with interest. But C cannot say that, oh, you gave me, I take, I did not ask you. I did not ask you, but suyamoto you give, I enjoy, is what C cannot say. C cannot say. So C has a quasi contractual obligation to pay that. When we go to bank and take money, the excess money is paid, it is our duty to return that money to the banker. So these are the quite common issues take place in purchasing and selling issues. And payment by coercion, sometimes what happens is certain payments are made with a fear of an act IP criminal in Indian Penal Code. Suppose if you don't go, I commit suicide. If you don't do it, I will kill you. I will break your head. Your wife will not come back from office. Your son will not come back from school, like that. Insisting one criminal offence, threatening to commit some criminal offence, if one person makes other to give his consent, that constitutes coercion. In free consent chapter, I explained in detail with about the free consent, free consent, coercion, unusual, fraud, misrepresentation, mistake, and all these things. I explained in detail under section 15 to 22 of the Indian Contract Act. So here there are some of the SSCs pay income tax. So the salary salary after deducting income tax only, salary is paid. After deducting income tax only, arrears are paid. After deducting income tax, treasury will deduct income tax as per their rules and will credit the pension. So however, there are certain circumstances, the pensioners or salaried people are entitled to, after filing the returns, if the tax is paid excessively, and GST or commercial tax or octroi duty, excise duty or anything they are paid excessively, the government has a duty to, has a quasi contract obligation to return it. The government should not, or government on behalf of government, the officials should not deny it. If so, it amounts to breach of contract, quasi contractual obligation. So this is what there are some two relevant cases on this point. One is there are relevant cases. Some Indian Bank versus Macro Electronics Limited, Andhra Pradesh High Court judgment. What happened is, in this case, Indian Bank gave wrong credit. It is quite obvious in the, but when we get credit, or now and then we receive messages from banks whenever amount is credited, whenever amount is debited. It's quite common in our regular course of life, in our modern banking system. And sometimes when we get debit, when we get credit, we are expected to know. Some people, busy customers may not know. Sometimes what happens is, bank while giving a credit wrongly gives credit to one customer instead of another customer. While giving a credit, even one account number, one digit is changed. Then it gets credited to some other customer. Then after some time, when if the bank realizes it, banker realizes immediately, he can revert it to the bank, revert it. But if a banker doesn't realize it, he keeps quiet. The customer who received the balance credit, and maybe under the impression that some amount is credited by some party, like that, he made use of that amount. When a real owner made a complaint to, real account owner made a complaint to bank after investigation detects that the amount was credited, but credited to wrong account. When account was credited to wrong account, if that wrong account holder is contacted, he should return that money with interest if necessary. He should not say that I did not steal anything from bank, you credited, I enjoyed, is what the person who received wrong credit should not say. So if he does so, an action can be instituted at the bank. Not only civil liability but also criminal liability will be there. So this is when wrong credit, when we receive credit by a bank from wrong sources, the duty is there to return the money. In this particular case, Indian Bank, this Macro Electronics is asked to return the money which was utilized by them. And similarly, Maharashtra Distilleries versus Municipal Corporation Aurangabad. In this particular case, excessive octroi duty was paid to the Aurangabad Municipal Corporation when the excessive amount was demanded by the Maharashtra Distilleries Company. Initially, the government authorities denied it. In an action by the Distilleries Company, Maharashtra Distilleries Company, the court said that there should not be any scope for unlawful enrichment, and the Municipal Corporation of Aurangabad was directed to return the money. These are the various issues. Chapter 5 containing section 68 to 72 of the Indian Contract Act provides for 5 kinds of quasi contracts. They are necessity supplied to minor, section 68. It is an exception to minor's liability. In this particular case, minor is liable. Second one is payment made by interested person, section 69. 69. If a tenant pays house tax on behalf of house owner, he is entitled to get the amount back. Owner cannot deny. The Non-Gratuitous Act. So wrong delivery is given by Amazon, Courier, etc., including perishable items like usable, consumable products, eatable items. Then that is non-gratuitous, section 70. Finder of lost goods, section 71. Whenever a person finds an article lost by somebody, that person is called finder of lost goods. When he finds a article lost by somebody, he has to he should take care of it, find out the real owner and hand over it. That is section 71. Last one is payment made by mistake or coercion is the last topic for a discussion. So with this, quasi contracts is over. Thank you very much, dear friend. After this lecture, next lecture, only 2 topics are left over. One is wagering contract and contingent contract. These 2 topics may be asked for short notes. And next one is remedies. Hadley versus Baxendale is a burning topic in it. Assessment of damages is a good question from that. And last one is I will take one more lecture on contracts one. What are the important questions? How to prepare for any subject preparation? You have to prepare notes of your own in a brief, in a limited pages, so that it can be easy for you to refer before the examination. But it is not possible to refer in one day. Exam to exam, there will be 1 day gap. In 1 day, it is not possible to refer books containing so many pages. Thank you very much for your patient hearing. After this contract 2-3 is over, Constitutional Law 2 topics I will take: judicial activism, independence of judiciary, then parliamentary privileges, services, doctrine of pleasure, and center-state relations, emergency provision. These topics I will have to cover from Constitutional Law 2. And writs and others, public interest litigation I have already covered in administrative law. And next I will take up family law to succession, and Hindu marriage, Muslim marriage also I have to cover. First of all, I will cover these topics, then I proceed to other subjects also. Anyway, I have an inclination to complete all the subjects. If you spare interest, I can have good inspiration. Thank you very much for your patient hearing. Those who have taken initiative, who have shown interest to watch my lecture from beginning to the ending. Thank you very much.